Good afternoon to all of you. Am I audible to you?
Yes, sir. Audible, audible.
Yes, thank you very much. Once again, we are here with the LAWVS new session, and I'll apprise you about the LAWVS. LAWVS is a dedicated platform to nurture the growth of young lawyers who aspire to excel and becoming leading figures to the legal profession. To support this vision, LAWVS regularly organizing learning sessions with the esteemed legal expert to provide practical knowledge and enhance legal skills. In this present session, Sh.Vinay Kumar Garg, senior advocate and distinguished expert, will address young lawyers on the important topic of remedies available after an arbitration award. The session will offer you clarity on the post-arbitral procedure, appeals and enforcement of the award, covering legal remedies. Young legal professional will greatly benefit from the advocate Garg's expert insights, practical and example, and engaging discussion. Lobbyists encourage all ambitious young lawyers, especially those interested in alternative dispute resolution, to take advantage to this valuable learning opportunity. This interactive session promises to strengthen their professional foundation and prepare them a successful legal career. Participation will be definitely excel the growth of young lawyers. Welcome you, sir. uh, Vinay sir says one thing which is very important, then I'll come to the Vinay sirs. जाति धर्म से होकर दूर, न्याय दिलाना बस दस्तूर. जाति धर्म से होकर दूर, न्याय दिलाना बस दस्तूर. निर्दोष कहीं फंस न जाए, यह कोशिश करना भरपूर. संविधान का पालन करके जो मानवता को बोता है, संविधान का पालन करके जो मानवता को बोता है, शोषित जन की लड़े लड़ाई वह अधिवक्ता होता है. शोषित जन की लड़े लड़ाई वह अधिवक्ता होता है. ये वर्ड मेरे नहीं है, हमारे जो स्पीकर हैं श्री विनय कुमार गर्ग जी के. ऑलवेज से सो. श्री विनय कुमार जी, शॉर्ट इंट्रोडक्शन, is a distinguished senior advocate practicing primarily in High Court of Delhi and Supreme Court. He regularly appears before various forums including NCLT, NCLAT, NCDRC, TDSET, etc. He is an extensive experience in arbitration, both as an arguing counsel, as an arbiter also. He has previously represented the government of Haryana as a standing counsel between 2001 to 2004, leading all the cases of state of Haryana before the Supreme Court. With a flourishing career of more than 30 years, he has been the primary counsel for numerous government departments and their instrumentalities such as GAIL, HPCL, IGL, etc. In addition to the above, he had been elected as a senior executive member of the Supreme Court Bar Association in the year 2019, thereby discharging duties as a chairman of the Library Committee, as also the Finance Committee. He has also been associated with the Federation of the Leprosy organization in fulfilling his responsibilities as a member of the society, and he is doing wonderful things for the legal fraternity. Thank you very much, sir, for giving your valuable time to the young lawyers, because this platform is totally dedicated for the young lawyers. Thank you very much, sir. A big round of applause to Vinay Kumar Garg, sir. Sir, thank you very, very much, sir. Thank you very much. Please.
Thank you, Dr. Sharma. In today's interaction, we are, as the topic introduced, we are discussing with the remedies against an arbitral award. Now, what I propose to speak about the remedies, I propose to speak in 4 parts, namely, what is an arbitration, number 1, and what is the historical perspective about arbitration in India, and thirdly, the arbitration law as it exists today. Now, why I said 4? Because the third, namely the arbitration law as it exists today, all of us know is 1996 Act. But the 1996 Act has 2 periods. One is prior to 2015 and other is post 2015. So post 2015, to the extent of remedies, etc., the Arbitration Act has become almost a new act. Now, starting with what the arbitration is, as all of us know, arbitration in simplest definition, though there is no statutory definition available, it is a mechanism for dispute resolution by a mutually agreed forum or tribunal or whatever you may call it. Now, if we talk of ancient India, then in ancient India, we have a long tradition of arbitration, and arbitration has long been prevalent in our country. We had community-based system of dispute resolution, which was exemplified by panchayat system and various courts established by different monarchies in our country. Of course, at the fountainhead was the king, which we today, the role which the today's courts are discharging. But we have definite tradition of arbitration in India, and this we can find in our sculptures, in our various literature which is available, and all those things, and even in our mythological system, we have the traces of arbitration. Now, this position about the uncodified form of arbitration continued even in colonial India, and this position continued till the year 1899. Now, all the audiences must be curious to know that in 1899, for the first time, British introduced Indian Arbitration Act in India. And that Indian Arbitration Act of 1899 was in fact a mirror image of the British, namely the English Arbitration Act 1889. So they had introduced an Arbitration Act 10 years before in England, which was later on brought into India, and we got the first Arbitration Act in 1899. Now that Arbitration Act, incidentally, had a very, very limited application, namely in Madras, Bombay, and Calcutta. So rest of the country, this act did not apply. Now we had certain other statutes wherein arbitration was mentioned, but the major change came when Civil Procedure Code was introduced in the year 1908. The original Civil Procedure Code, it contained a specific section which provided for settlement of dispute outside court, namely by arbitration. Now, this laid the foundation for a codified law of arbitration in India, and the actual codified law for arbitration later on came in the year 1940 by way of an Arbitration Act 1940. Now, if you see Arbitration Act 1940, then you will find that it has repealed the provisions contained in the Code of Civil Procedure of 1908. So, henceforth, from 1940, you had an Arbitration Act in place, which continued till the year 1996, as all of us know. Now, if we look at the 1940 Act, it has a definite scheme of arbitration, a court-monitored arbitration, as also the parties instituted and parties agreed arbitration. But when an award was made in the 1940 Act, the challenge to the award was, if you see the Act, could have been made under section 14 to 19, read with section 30. Now, if we go to what there was in those provisions, then there was very limited scope for the court to interfere, and the court could interfere only the imperfection, the clerical mistake under 14, or if it was beyond the terms of the reference. These were the three grounds which were there in 14. Then 16, court had the power to make remit the award in case the court find that the award is either indefinite or incapable of execution, or there was some error apparent. Now, section 30, which was the main provision, like we have now section 34. Section 30 of the Arbitration Act 1940, it contained three principal grounds on which an award could be challenged. Now, the first ground was the misconduct. Now, misconduct under the 1940 Act could be of two kinds. One, misconduct committed by the arbitrator himself, fraud, corruption, this, that, etc., or misconduct in conduct of arbitration proceeding. Now, the second ground was that the arbitration was without jurisdiction, namely that some provision, some dispute which was not referred or which was not arbitrable, that has been entertained by the arbitrator, and therefore that was also a ground to challenge the award under the 40 Act. The third ground was that the arbitration award was improperly procured. That was a ground which, as I told you, which will have some interpolation with misconduct part, because improperly procured, as the courts have defined, would mean that it is procured by fraud, bias, or corrupt practices. Therefore, the courts have had very, very limited jurisdiction, very, very limited scope. But section 30 also provided that the court could interfere if the arbitration award was otherwise invalid. Now, this otherwise invalid, it gave a great room for interference or monitoring, I will call, by the courts in India. And that is the position which continued till 1996. Now, in otherwise invalid, the concept of perversity was introduced, the concept of patent illegality was introduced, the concept of public policy and violation of public policy was introduced, and also the concept of award being contrary to the terms of the agreement between the parties was accepted by the courts, as these were the principal challenges, principal grounds on which challenges were entertained. If the viewers wish, then they can see that there is one judgment of the Supreme Court, that is AIR 1976, Supreme Court 1745, Union of India versus Om Prakash, wherein Supreme Court has laid down all these grounds and factors on the basis of which an arbitration award under the 1940 Act could be challenged before a court of law. There are other judgments which provided the limits of the court's jurisdiction and the extent to which the court could interfere, etc. But the fact remains that courts primarily had entertained challenges only on these four parameters, but the fact remains that these four parameters also were to some extent court-centric, rather judge-centric, and were interpreted differently in different judgments. So there was a lot of room for interference with the arbitration awards under the 1940 Act. Section 34, 37 of that act, of course, provided for appeal. And this position, while this position was going on, then in 1978, a report of the Law Commission came, that was the 76th Law Commission report. That report, viewers will be interested to know, was written by the then chairman of the Law Commission, legendary Justice, I will call, Justice H.R. Khanna. Justice H.R. Khanna in that report noticed all these things, the working of the 1940 Act, as also all those acts which were then prevalent till 1940 Act came, and traced the history also of arbitration in India. Justice Khanna made several recommendations, but the fact remains that the legislature did not act on any of those recommendations. In the meantime, in 1985, the United Nations Commission on International Trade Law, that is UNICITRAL, adopted model law on commercial arbitration. And that was a big development internationally, which affected everyone, including India. This UNICITRAL model, this recognized arbitration, and not only arbitration, but mediation, conciliation also, as one of the alternate dispute resolution mechanism, ADR as we call it. As all of us, and many of us rather, would know that in 1991, India opened its economy and we started integrating ourselves economically with the world order. And therefore, there was a need felt to have a robust arbitration system in India, so that the multinational companies who were coming and all those who were intending to have business interests in India, they could be sure about an acceptable model of arbitration where they could have thought of reasonable speed with which the disputes, commercial disputes in particular, will be resolved. I remember that when late Shri Arun Jaitley ji, he became the law minister for the first time, Bar Association Delhi High Court Bar Association had a felicitation function for him. And in that felicitation function, which I distinctly remember, Mr. Jaitley pointed out one thing, that lawyers, please remember, new commercial law regimes are coming. Be prepared. It will be a law which will be very new to you, and it will flood your courts with commercial litigation. And today we see the result. Nonetheless, when Mr. Jaitley made this comment, the 1996 Act had come in. Now, 1996 Act, how it was brought in? It was brought in initially by way of an ordinance of 1995, and then the Act came in 96. Now, 1996 Act, if we see the initial 1996 Act, it has provided under Section 34 grounds for challenge of the arbitration award. Now, if you see this, then Section 34 of the arbitration award, then in subsection 2 of Section 34, the arbitration could be set aside, award could be set aside by the courts only and only if, the word used was only if, the party was under some incapacity, that is one. Two, the arbitration agreement itself was not valid. Three, the party making the application was not given proper notice of the appointment of arbitration or of the appointment of the arbitrator. Four, the arbitration dispute which was decided by the arbitral tribunal was not within the terms of reference or was not contemplated by the parties. And then composition of the arbitral tribunal was not in accordance with the agreement of the parties. Now, these all were procedural. Now, the main ground of challenge was in section 34(2)(b), namely that the subject matter of dispute is not capable of being settled by the arbitration. Like we know that there are many disputes which are held to be not arbitrable, like for example, the matrimonial disputes, for example, the disputes relating to service, etc., and all that kind of disputes. Two, that the arbitration award is in conflict with public policy of India. Now, once again, like section 30 of the 1940 Act, the public policy of India, it came in and it was interpreted by the courts in different judgments, and that became a point of disputes in the court, and law progressed, as all of us know. Now, this phrase, public policy of India, it was not defined anywhere. The courts traced the first judgment on the question of what is public policy of India in a judgment called Renu Sagar Power Limited. That's the first judgment wherein the public policy of India phrase was defined by the Supreme Court. That is 1994 Supplement 1 SCC 644. Now, that judgment incidentally was with regard to Foreign Awards Recognition and Enforcement Act 1961. It was not a case of Arbitration Act 1996 or 1940. But the Supreme Court in that judgment said that public policy means three things. One, that if it is fundamental policy of Indian law, then it is public policy of India. Interest of India, justice or morality. Now, these were the three factors which were defined by the Supreme Court to constitute public policy of. So, if an award is against the fundamental policy of Indian law, if it is against the interest of India, or if it is against justice or morality, then the award was questionable and could be questioned. Now, this position was noticed by the Supreme Court thereafter in next judgment, that was Saw Pipes. Saw Pipes was a judgment which actually was under Arbitration and Conciliation Act. Now, in Saw Pipes, if we see Saw Pipes, the Supreme Court introduced one more factor into this public policy of India. Now, court said that no, if public policy of India cannot be given a narrower meaning. It will have to be given a wider meaning. So given the wider meaning which we need to adopt and which we adopt, it cannot be stated that public policy of India includes only these three factors. They said that in addition to these three, patent illegality also is part of public policy of India. So now viewers kindly note this. This patent illegality, it was introduced in public policy of India. Now for this patent illegality also Supreme Court said that illegality has to be an illegality which is not of trivial nature but must go to the root of the matter. So far so good. Thereafter, in Western Jacob, that was a 2014 judgment, the Supreme Court went a step further. And if you see Western Jacob, they introduced something new into this patent illegality, and I will say in fundamental policy of India, that a concept that the award is such which no reasonable person would have arrived at. Now this was really wide. Now you have the concept that no reasonable prudent person could have arrived at such a conclusion, and if that is accepted, then that opened room for interference, reappreciation, everything by the courts in the matters even of arbitration. Then came the 2015 judgment of Associated Builder by Justice Nariman. Now the viewers kindly see that judgment with a little more interest, because that judgment further amplified, and it amplified interference to an extent which even after, to a great extent, under post 2015 amendment, large part of it is still retained. Justice Nariman said that juristic principle of judicial approach demands the decision be fair, reasonable, and objective. Now this also is introduced. Now he said, if we have to test the award on the basis of fair, reasonable, and objective, then anything which is arbitrary or whimsical would not be a determination which will either be fair or reasonable or objective. Now the next juristic principle which Justice Nariman accepted, that if the award is so perverse and so irrational that no reasonable person would have arrived at, then the same is important and requires some degree of explanation. Now he introduced three elements to it. One, that the finding is based on no evidence. That is, all of us know it is perversity. That the tribunal takes into account something which is irrelevant to the decision which it arrives at. So that also is a ground of perversity. Or it ignores vital which is available on record. So all three factors of perversity is also introduced. Now this all continued, and the legislature as also the government, they studied the working of the 1996 Act. The economy, as all of us know, was growing at a very fast speed, and so were the disputes. So the Law Commission of India, in its 176th reports, they studied this 1996 Act and its working in great extent and in great detail. And they noticed various shortcomings, as also the increased interference by the courts in the matters determined by the arbitral tribunal. Now, the result of this 2001 report of the Law Commission was that immediately after this judgment of the Supreme Court in Sopai, a bill was introduced in the Rajya Sabha. The Rajya Sabha also appointed a committee called Justice B.P. Shroff Committee to study the Act, the report of the Law Commission, as also the bill which was introduced in the Rajya Sabha. Now, this report, this commission, Justice B.P. Singh Commission, it gave its report in 2005, and the matter was referred to the Standing Committee of the Parliament. The Standing Committee of the Parliament, its report came in August 2005, and it's noticed the report of Justice B.P. Shroff Committee, which had pointed out glaring infirmities and also pointed out that courts were increasingly interfering in the matters of arbitration awards in India, and which was not the spirit of the 1996 Act. And that's how the 246th Law Commission report, as all of us know, came in 2015. And along with that report came this Justice Nariman's judgment in Associate Builders, which I just now read to all of you in 2015. All of us know that in 2015, this Act was amended. Now, the Act was amended to great extent, but confining to today's topic, the Section 34 was also amended, and a new kind of Section 34 retaining some portion of the old and introducing new concepts came in. Now, if you see Section 34 now, then Section 34(2)(a), it contained all the four, namely that party was under some incapacity, agreement was valid or not valid, party was given a notice or not given a notice, or that the award is on a dispute not contemplated by the agreement. One more factor, namely that composition of the arbitration tribunal was not in accordance with the agreement. Now, B, which earlier had two elements, namely, and the primary element was public policy of India, it was now changed because this public policy of India concept was causing a lot of discomfort in the matters of international awards and international arbitrations, wherein the seat of arbitration was outside India. Now, the new section B said the subject matter of the dispute is not capable of settlement by the arbitration, same as the previous one. 2, the arbitral award is in conflict with public policy of India. So far, same. But an explanation was introduced. Explanation said that for avoidance of any doubt, it is clarified that an award is in conflict with public policy of India only if now the definition of public policy of India is limited. The making of the award was induced or affected by fraud or corruption, or was in violation of section 75 or 81, or it is in contravention with fundamental policy of Indian law. So the Renu Sagar, Saw Pipe, both were retained. 3, it is in conflict with most basic notion of morality and justice. Now, explanation 2 said, for avoidance of doubt, the test as to whether there is a contravention with fundamental policy of Indian law shall not entail review on merits of the dispute. So the concept which Genco introduced, that no reasonable person would have arrived at, that was legislatively done away with. Now, under 34 now, a new subsection, namely subsection 2 capital A, was also introduced by the legislature. Section 2A said that an award arising out of arbitration other than international commercial arbitration, now please note this, may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award. Now, what is the change? Change is that prior to 2015, patent illegality was a concept which was read into public policy of India. So, public policy of India was applicable to international commercial arbitration also. Now that has been taken away from international commercial arbitration. So if it is a international commercial arbitration after 2015 Act, then the ground of patent illegality becomes unavailable. So patent illegality is now taken out of public policy of the policy of Indian law, or the public policy of India, and is introduced as a separate independent ground confined in its applicability to domestic arbitrations. So if you have an international commercial arbitration and you are challenging it under 34, then patent illegality is a ground which is inapplicable. You cannot challenge it on the ground of patent illegality. Now, the Act also introduced 2 new subsections, namely 5 and 6, which are not relevant. Now, after this 2015 amendment came, Justice Nariman is still holding the chair in Supreme Court. After this associate builders, Justice Nariman again had an occasion to deal with the Arbitration Act or the challenge to an arbitration award in Sangyong. And that is a judgment of 2019. 2019 volume 15 SCC 131. Now, in para 34 of that judgment, the court said public policy of India whether contained in 34 or 48 would now mean fundamental policy of Indian law, which is explanation 1. So it is not no more left to the courts to define what is public policy of India. It is statutorily, legislatively defined as fundamental policy of Indian law. Now, if it is fundamental policy of Indian law, does it mean that you cannot examine those 3 principles which were laid down in Renu Sagar and the 4th in Swapai? No. They were still applicable because they were held to be part of fundamental policy of Indian law. Now, the fundamental policy of Indian law, the court said, will be the same as was laid down in Renu Sagar and Swapai. But the court also noticed that this Western JACO judgment, which said that reasonable, prudent person concept, that has been legislatively done away with. But the Supreme Court now had the task of protecting the interest of people and protecting the purity of law in the matters also of commercial arbitration. So the court said that, all right, now you can challenge the award on the basis of fundamental policy of Indian law, but if the award is against the basic notions of justice and morality, as was laid down by the court in Associate Builder, then also it is against the fundamental policy of Indian law. Now, the court did not stop here. And if you see that fundamental policy of Indian law was held to be contravention of a statute not linked with public policy or public interest, but when it comes to setting aside of an award on the ground of patent illegality, then patent illegality, of course, now recognized, statutorily recognized as a ground on the basis of which award can be challenged. If you see this judgment of Justice Nariman did not stop here and once again pointed out that perversity is also a ground which is part of public policy of India. It was held part of public policy of India in this Associate Builder, Renu Sagar and all those judgments. But since the statute now says patent illegality, so now this part, namely perversity, will have to be read into the concept of patent illegality. And the court said that a finding based on no evidence at all or an award which ignores vital evidence in arriving at its decision would be perverse and liable to be set aside on the ground of patent illegality. But courts also introduced that if the award is based on, or the finding in an award is based on some documents taken behind the back of a party, that also will qualify to be a decision which is perverse. Now, this was taken a new height by Justice Ellen Rao in DMRC, that is judgment of 2011. And Justice Rao said that patent illegality, of course, has to go to the root of the matter, and every error of law cannot be committed by an arbitral tribunal, cannot be read into the concept of patent illegality, or erroneous application of law will not be categorized as patent illegality. Those are the concepts which are available to a court which is hearing an appeal, and challenge to an award under Section 34 is not the appellate jurisdiction but examining the validity of the award on the strict principles, on the strict grounds which are laid down in Section 34(2). The court said that, but if you read DMRC judgment, the court once again introduced JECO. Now the court says the permissible grounds for interference in a domestic award under 34(2)(a) on the ground of patent illegality is when the arbitrator takes a view which is not even a possible view, or interpret a clause in the contract in such a manner which no fair-minded or reasonable person would. Now you remember I just now mentioned to you that in JECO, this was the concept which was introduced, and Justice Nariman in Sangyong Engineering said that this was statutory overruled. It is no more available. But in DMRC, Supreme Court reintroduced this concept, and this concept till date holds the field. Now all these judgments have gone, and the viewers will note two more judgments which are very interesting and which are path-breaking judgments. One, Sal Udyog Private Limited judgment, wherein the court said that though the post-2015, there is an amendment under Section 28(3), to the extent that prior to 2015, the arbitral tribunal was to pass an award in terms of the agreement, and post 2015, the arbitration award was to be in accordance with the agreement. But the court said that if you ignore the terms of the agreement, then that would be a case of patent illegality and therefore questionable. Now, all this went on till the recent judgment of the Supreme Court, a 3 honorable judges bench judgment, beautifully authored by Justice Manoj Mishra. That is a 2024 judgment, 2024 SCC Online 2600. This judgment, viewers, collate the entire position of law, the march of the law under 34 till date, and clearly calls out the principles which can be read from Sangyong, DMRC, Salvyor. So therefore, today what we have is a broad principle of fundamental policy of law in India, which follows Renu Sagar and associate builder, and patent illegality, which was introduced by Saw Pipes in 2003 and legislatively retained in the Arbitration Act, as also the concept of a reasonable prudent man, which is noticed and approved by the Supreme Court in DMRC. So under 34, these are the limited grounds. So whenever you make a challenge to an award, keep in mind that these are the fundamental judgments and these are the judgment and this is the line of judgments which you need to keep in mind while framing your challenge to an arbitration award. Now, in the interest of time awarded to me by Dr. Sharma, I need to stop here. Otherwise, this topic, according to me, is a topic which cannot be contained in this 60-minute capsule which is given to me. And I have tried my best to bring into you all the judgments, though there are many more judgments which I could have pointed out. But in the interest of time and in the interest of limited time with all of you, I have given you the basic judgments which have been followed by the courts. Thank you so very much for all of your attendance and patience. Thank you.
Thank you very much, sir. As we extend our heartfelt gratitude to you, sir, for delivering such an enlightening and thought-provoking session. Sir, your deep understanding and reaching the law, practical insight, and inspiring words have truly enriched all the participants. The clarity which you explain complex legal principles and share your courtroom experience was really remarkable. Your guidance has undoubtedly motivated the young lawyer to pursue the excellence and integrity in the legal profession. And this is the only motive of LAWVS. Thank you very much. If somebody wants to ask any question to sir, so they can ask. This is really wonderful. Sir, I'll take 1 minute, sir. We started the entire gathering and only from starting to till now, only two of the participants have left the lecture, and this is really, truly wonderful that the all participants remain for an hour, absolutely listening all these judgment which you have said so, sir, and it is really thankful to all of you. I was counting all the numbers and how many are again and again they are listening all these things, and this is really wonderful, and I'm really deeply obliged you, sir. Anybody can ask.
Sir, it was very wonderful joining this session. Sir, thank you for conducting this session. It was very valuable for me and my team too. We are all joined from one VC.
Thank you, Mr. Tyagi. Thank you.
Thank you, Rohit ji. Thank you.
Thank you, sir.
Anybody else?
Sir, may I ask 3 or 4 questions in just 30 seconds,
Yes.
which I face as a young corporate counsel, sir?
Yes.
Sir, what is the first is what is the validity of online dispute resolution? Because for a 60,000, 80,000, 1 lakh rupees dispute, it's not viable for me to go to regular arbitration. Second is what should be the rate of interest if I succeed in an arbitration, and what should be the costs imposed upon me in an arbitration? And can an arbitration be challenged on that ground itself? Thirdly, sir, you quoted this is not a problem with arbitration, but it's a problem with every field of law. Our judges are in the habit of essay writing, sir. So, sir, some decisions are in some of the principles, those flow from the judgments are obiter. And if I am arguing from this side, I quote those judgments. If I am from the other side, I say these are not ratios, these are orbiters. How to tackle that problem? And fourthly, sir, this is the last question. Sir, Section 17 applications, for example, freezing of accounts and all. If I get a judgment in arbitration, sir, on Section 7, if I get an order, so as to say, some banks accept it, some banks don't accept it. They do not take action upon it. So, sir, what is the step to be taken in that regard?
See, as regards the online dispute resolution, it is only a mode, which utilizes existing dispute resolution system. There is no statutorily prescribed separate online dispute resolution system, that you put something online, you put your dispute and somebody puts his defense to it, and that can be resolved. There is no such system in place till date. I wish that we can have for smaller value disputes, like you said, that disputes under 1 lakh or something. And that's why perhaps the legislature has also provided in 1996 Act the procedure for conciliation. So conciliation, now Mediation Act also has come in. These can be the methodologies which can be accepted and applied. Now, as regards interest, interest is something which can be awarded by the courts in commercial matters either under the Interest Act, that's one, or if the agreement between the parties prescribe any particular rate of interest. I remember appearing in one matter wherein the rate of interest prescribed was 18% with quarterly rests. And the plea taken before the court was that it is unreasonable. The court said that though it was not an arbitration dispute, it was a commercial dispute, of course. Court said that, look here, in a commercial dispute, when we are enforcing the agreement between the parties, and the agreement is a commercial agreement, then the principles of contra profantem, etc., are inapplicable. You have entered into this agreement with open eyes, and the interest provided is also an agreed term between the parties. So therefore, the rate of interest up to the arbitration will have to be in terms of the contract. Now, there are 3 stages of interest, as all of us know. One is up to the date of the list, which is brought in. Here, it is an alternate dispute. So, the dispute on the date when the reference is the arbitration agreement is invoked. 2, pendent alike, namely during the pendency of the arbitration proceeding. And 3rd, post the arbitration award. Now, the initial judgment was Saeed Ahmed and Company judgment by Justice Ravindran, wherein Justice Ravindran had, in his signature style, I will say, he has written all his judgments with extreme clarity, and everybody, whether he is a student of law at the first stage of the law school, or an advocate after spending 20-30 years as advocate like me, we are able to understand his judgments with utmost clarity. The flow of language, the clarity which he writes, he had in Saeed Ahmed and Company. Incidentally, that was a case wherein I appeared as a counsel. Justice Ravindran had laid down this principle of law that interest up to the proceeding contractual, pendent alike, and future regulate. Now, the recent judgment, Constitution Bench judgment by Justice Khanna, as Chief Justice Khanna, that also reiterates the same position, that post award, court can regulate, and therefore the contractual term of the agreement will be applied only up to the date of the arbitration. Now, as regards 17, though today is not the this was not the topic, but 17 is an interim award, and there is a interim order which court can make, which arbitral tribunal can make. Court can make under 9, tribunal can make the under 17. Now, if an order is made, then there are remedies provided, and those will have to be exercised. Now, any other question by anybody?
I think Jagannath ji, you satisfied?
Sir, only one question left regarding that obiter and ratio.
I'm sorry, I missed that question. Can you repeat that?
Sir, not only in arbitration, sir, there are various principles in every branches of law. But what happens is, as a young counsel, when I argue those points, no, from the other side, I get this counter that these are only arbiters. These are not on the facts of the cases. So this is not applicable. These are not ratios. And I also argue the same way from the other side, if I get an opportunity.
Now, if I may answer, though that is not a arbiter and the stray decisis is not a question which is confined only to Arbitration Act or something. It's a general question of law. But yes, arbiter of a constitutional court, like arbiter made by the Supreme Court, is binding on the High Court, and High Court cannot refuse to be obeyed or to be bound by even by an arbiter of the Supreme Court. Same way, a court of subordinate jurisdiction cannot refuse to be bound even by an arbiter on law by a superior court. So that remains the position. So a judgment of a superior court, namely the High Court or the Supreme Court, cannot be refused to be accepted before a court court of subordinate jurisdiction only on the ground of arbiter, and under 141 even the arbiter under Article 141 of the Constitution, even an arbiter made by the Supreme Court is a law.
Thank you so much, sir, for the clarity.
Welcome, sir.
Thank you very much, sir. Thank you very much to all the participants, sir. Thank you for the wonderful session, sir. Wonderful session.
Thank
Thank
you.
you very much. Thank you, sir. Thank you very much.